Multiple choice questions. Part 1, Companies Act 2013. Roma Limited. Roma. Part 1, Companies Act 2013. First question. Roma, along with her six friends, has incorporated Roma Trading Limited in May 2019. The paid-up share capital of company is 30 lakhs. Further, in April 2020, she noticed that in the last financial year, the turnover of the company was well below 20 crores. Advise whether the company can be treated as a small company. Option A, Roma Trading Limited is definitely a small company since its paid up capital is much below 2 crores and also its turnover has not exceeded the threshold limit of 20 crores. Option B, the concept of small company is applicable only in case of private limited company OPC and therefore despite meeting the criteria of small company it be a public limited company, it cannot enjoy benefit of small company. C. Unlike a private limited company, OPC, which automatically becomes a small company as soon as it meets the criteria of small company, Roma Trading Limited, being a public limited company, has to maintain the norms applicable to small company continuously for 2 years so that therefore thereafter it will be treated as a small company. Option D. If all the shareholders of Roma Limited give an undertaking to the ROC stating that they will not let paid up share capital and also turnover exceeds the limits applicable to small company in the next 2 years, then it can be treated as a small company. Answer is option B. The concept of small company is applicable only in case of a private limited company OPC and therefore despite meeting the criteria of small company, it being a public limited company, it cannot enjoy benefit of small company. Question 2. Abhilasha and Amrita have incorporated a not-for-profit private limited company which is registered under Section 8 of the Companies Act 2013. One of their friends has informed that their company can be categorized as a small company because as per the last profit and loss account for the year ended 31st March 2019, its turnover was less than 20 crores and its paid up share capital was less than 2 crores. Advice. Option A. A Section 8 company which meets the criteria of turnover and paid up share capital in the last financial year can avail the status of small company only if it acquires at least 5% stake in another small company within the immediately following financial year. Option B. If the acquisition of minimum 5% stake in another small company materializes in second financial year after meeting the criteria of turnover and paid up share capital, then with the written permission of concerned ROC, it can acquire the status of small company. Option C. The status of small company cannot be bestowed upon a not-for-profit company which is registered under Section 8 of the Companies Act 2013. Option D. Section 8 company, if incorporated as a private limited company, can avail the status of small company with the permission of concerned ROC after it meets the criteria of turnover and paid up share capital. Answer is option C. The status of small company cannot be bestowed upon a not-for-profit company which is registered under Section 8 of the Companies Act 2013. Option C is right answer. Question 3. Namita Ceramic Good Limited having 152 members was incorporated with the main objective of manufacture of ceramic goods, glazed, unglazed floor and wall tiles, etc., and to carry on trading in such. Question 3. Namita Ceramic Goods Limited having 152 members was incorporated with the main objective of manufacturing of ceramic goods, glazed, unglazed floors and wall tiles, etc., and to carry on trading in such product after 3 years of successful operation it wants to diversify its business by entering into the field of manufacturing electronic goods, for which it is required to alter its object clause. Advise the company in relation to alternate alteration of memorandum. Option A. The company can alter its memorandum of association by passing an ordinary resolution and obtaining a confirmation of the regional director. The company can Option B. Company can alter its MOA by passing a special resolution at shareholders meeting. Option C. Company can alter its MOA in relation to the objects clause by passing a special resolution at the shareholders meeting and obtaining the confirmation of the regional director. Option D. A company can alter its MOA in relation to object clause by passing a special resolution at the shareholders meeting and simultaneously publishing the content of special resolution in two newspapers, one in English and other in one vernacular language circulating in that area. Answer is option B. Company can alter its memorandum of association by passing special resolution at shareholders meeting. Question 4. Due to the management disputes, Flow Writing Industries Limited could not hold its current annual general meeting by latest due date. Even after lapse of due date, it seemed rather impossible to convene the AGM. In such grim situation, one option available was to approach NCLT and seek direction for the calling of AGM. Out of the following four options, which one is applicable in the given case? Option A. Any member of company can make application to the National Company Law Tribunal (NCLT) and seek direction for the calling of AGM. Option B. Member of the company holding at least 1% of the total paid up share capital must make an application to National Company Law Tribunal and seek direction for the calling of AGM. Option C. Minimum two members of the company holding at least 1% of the total paid up share capital must make a joint application to National Company Law Tribunal and seek direction for the calling of AGM. Option D. Minimum five members of the company holding at least 1% of the total paid up share capital must make a joint application to the National Company Law Tribunal and seek direction for the calling of AGM. Answer is option A. Answer is option A. Any member of the company can make an application to the National Law Tribunal and seek direction for the calling of AGM. Question 5. Anupam Incorporated, a one-person company with his sisters Alpana as the nominee, and about 3 years having passed satisfactory, Anupam does a number of charitable works and it is associated with three NGOs. His business under his OPC has also flourished. Now he is planning to convert the OPC into Section 8 company, a company formed with charitable objects. Choose the correct option. Option A. Since the company belongs to Anupam, he has full discretion to convert the OPC either as Section 8 company or as a private company or public company. Option B. Since the company was formed as a private company, the only option available with Anupam is to convert it into public limited company. Option C. There is specific prohibition on converting OPC into Section 8 company, otherwise it can be converted into private or public company without any hindrance. Since on option D, since Anupam does a lot of charitable work, there is no prohibition on converting his OPC into Section 8 company. Answer is option 5. Option C. There is a specific prohibition on converting OPC into Section 8 company, otherwise it can be converted into a private or public company without any hindrance. Question 6. An issuing house, stockbroker, share broker, has issued an advertisement in two leading newspapers for selling a large number of shares allotted to it by a company under a private placement. In which of the following condition will the advertisement not be deemed to be prospectus? Option A. Advertisement was given within 6 months from the date of allotment. Option B. Advertisement was given after 6 months from the date of allotment and the issuing house has paid the entire consideration to the company. Option C. The issuing house did not pay entire consideration to the company till the date of allotment. Option D. Advertisement was given within 3 months from the date of allotment. Answer is option B. Advertisement was given after 6 months from the date of allotment and the issuing house has paid the entire consideration to the company. Question 7. Which of the following statement is not true? V is not true. Option A. In case of share, the rate of underwriting commission is to be paid shall not exceed 5% of the issue price of the share. Option B. Underwriting commission should not be more than the rate specified by the AOA. Option C. In case of debenture, the rate of underwriting commission shall not exceed 5% of the issue price of the debenture. Option D. Amount of commission may be paid out of profit of the company. Answer is option C. In case of debentures, the rate of underwriting commission shall not exceed 5% of the issue price of the debenture. Question 8. Which of the following statement is contrary to provision of the Companies Act 2013? Option A. A private company can make a private placements on its securities. Option B. The company has to pass a special resolution for private placement. Option C. Minimum offer per person should have market value of 20,000. Option D. Public company can make a private placement of its securities. Option is Answer is option C. Minimum offer per person should have market value of 20,000. Questions 9. A self prospectus filled with the ROC shall remain valid for period of option A 1 year from the date of registration, option B 1 year from the date of closure of first issue, option C 1 year from the date of opening of first issue, option D 90 days from the date of which the copy was delivered to ROC. Answer is option C 1 year from the date of opening of first issue. Question 10. Sripad Religious Publisher Limited has received application money of 20 lakh 2 lakh equity shares of 10 each on 10 October 2019 from the applicant who applied for allotment of shares in response to a private placement offer of securities made by the company or to them. Select the latest date by which the company must allot the shares against the application money show received. Option Answer is option C 9 December 2019. Question 11. Being in need of further capital, Rimsey Cotton Silk Products Limited offer 50 lakhs equity shares of 1 rupees each to 50 identified persons on private placements basis, and accordingly a letter of offer accompanied by application the company the necessary form was sent to them after fulfillment of due formalities including passing of special resolution. One of the applicant, Rajan, made a written complaint to the company highlighting the fact that the offer letter was incomplete as well as illegal as it did not contain renunciation re as it did not contain reannuation clause, as he wanted to exercise his right of reannuation in favor of his son Uday. By choosing the correct option, advised the company in this format. Option A. As a right of and reannuation are right as the right of as the right of reannunciation. Option A. Reannunciation. Reannunciation. Question 11. Being in need of further capital, Rimsey Cotton Silk Product Limited offer 50 lakhs equity shares of 1 each to 50 identified person on private placement basis, and accordingly a letter of offer accompanied by application the necessary form was sent to them after fulfillment of due formalities including passing of special resolution. One of the due formalities including passing of after fulfillment of due formalities including passing of special resolution, one of the applicant Rajan made a written complaint to the company, highlighting the fact that the offer letter was incomplete as well as illegal as it did not contain renunciation clause. As he wanted to exercise his right of renunciation in favor of his son Uday by choosing the correct option, advised the company in this format. Option A: as the right of renunciation cannot be denied, the company needs to rectify its mistake by including the same in the offer letter and application form. Option B: a company is prohibited from the providing the right of renunciation, so or the offer letter and application form need not include any such clause. Option C: instead of absolute prohibition, the company can provide right of renunciation limited to 25% of offering. Option D: instead of absolute prohibition, the company can provide right of renunciation limited to 50% offering. Answer is option B. Company is prohibited from providing right of renunciation, so the offer letter and the application form need not include any such clause. Question 12. Innovative Tech Solution Limited, instead to invite subscription for 1.10 crore equity shares of 10 each on private placements basis, the person identified as potential subscriber as within the statutory limit, and also include the two other categories to which such a statutory limit is not applicable. One such category is employees of the company who are offered equity share under employee stock option scheme. The other excluded category is option A: qualified in institution buyer, option B: qualified institutional buyers, option C: qualificational institutional buyer, option D: qualified investing institutional buyer. Answer is option B: qualified institutional buyer. Question 13. Neptune Metal Tools Limited was incorporated on 2nd December 2018 with 25 subscribers and authorized capital of 50 lakh, 5 lakh equity shares of 10 each. The director of the company are in dilemma whether to issue share certificate to subscribers in physical form or in dematerialized form. Advise them correctly on these matters. Option A. Being an unlisted company, Neptune may either issue physical certificate to shares or alternately issue them in dematerialization form. B. Neptune need to issue share to the subscriber only in dematerialized form. Option C. A company having more than 100 subscribers need to issue shares in dematerialized form, and therefore Neptune may issue physical share certificate to the subscribers. A company having authorized Option D. Company having authorized capital of 50 lakh and above needs to issue shares in dematerialized form, and therefore Neptune may issue physical share certificate to the subscribers. Answer is option B. Neptune need to issue share to subscribers only in dematerialized form. Question 14. Amount. The amount that an unlisted public company is required to maintain as security deposit at all time with the respective depository when it dematerializes its securities shall be: option A equal to not less than 1 year fee payable to depository, option B equal to not less than 2 year fee payable to depository, option C equal to not less than 2.5 fee payable to depository, option D equal to not less than 3 year fee payable to depository. Answer is option B equal to not less than 2 year fee payable to depository. Question 15. Commission is permitted to be paid to any underwriter by the company only in respect of an offer of securities. Option A, where securities are offered on right basis. Option B, where securities are offered in form of bonus issue. Option C, where securities are offered on private placement basis. Option D, where securities are offered to public for subscription. Answer is option D, where securities are offered to public for subscription. Question 16. In case of offer of sale of in case of offer of sale of shares by certain members of the company, which of the following option is applicable? Option A, the provision related to minimum subscription are not applicable. Option B, entire minimum subscription is required to receive within 3 days of opening date. Option C, 25% of minimum subscription amount is required to be received on the opening date and the minimum and the remaining 75% within 3 days thereafter. Option D, 50% of the minimum subscription required to receive by the second day of the opening date and the remaining 50% within next 3 days after the second day. Answer is option A. The provision related to minimum subscription are not applicable. Question 17. The time limit within the which a company of a company of the contract for the payment of underwriting commissions is required to be delivered to registrar is option A, 3 days before the delivery of prospectus for registration, option B, at the time of delivery of prospectus for registration, option C, 3 days after the delivery of prospectus for registration, option D, 3 days 5 days from the day delivery of prospectus of registration. Answer is option B, at the time of delivery of prospectus for registration. Question 18. Shares issued by company to its director or employees at discount or for consideration other than cash for their providing know-how or making available rights in nature of intellectual property rights or value adding addition by whatever names called are known as option A, equity shares, option B, preference shares, option C, sweat equity shares, option D, redeemable preference share. Answer is option C, sweat equity shares. The AOA, question 19. The AOA of private limited company states that the company may issue preference shares which will have preference with respect to payment of dividend only but no preference as to the repayment of capital. In the case of winding up, is it possible for the company to issue such preference shares? Option A, no. As per section 43, preference shares should have both preferences. Option B, no. This will become an equity share as per section 43. Option C, yes, because as per section 43, preference shares should have any one's preference. Option D, yes, because article of association of the company allow issue of such preference shares and the issue company is private limited company. Answer is option D, yes, because article of association of the company allow issue of such preference shares and issuing company in a private limited company. Question 20. A general meeting of the company is to be held on 30th August 2020. The company has to pay dividend in respect of its private shares for the financial year 2018-19 as well as 2019-20. In such case, the preference shareholders option A will not have the rights to vote because preferential shareholders have no right to vote. Option B will have the right to vote because dividend has not been paid for the last 2 years. Option C will not have the right to vote because only equity shareholders can vote in general meeting. Option D will have right to vote because preferential shareholders have the right to vote in general meeting. Option is answer is option B will not have the right to vote because dividend has not been paid for the last 2 years. Question 21. Where there is a chance in the rights of one class of the shareholders of a company that also affects the right of another class therein, then option A, a specific resolution should be passed at a general meeting in this regards. Option B, company need not to do anything further. Option C, the consent in written of the 3/4 of such other class of shareholders shall also be obtained. Option D, a resolution at a joint meeting of both the class should be passed. Answer is option C. The consent in writing of 3/4 of such other class of shareholders shall not be obtained, shall also be obtained. Question 21. Rajesh Infrastructure. Question 22. Rajesh Infrastructure Limited wants to issue preference shares for a period exceeding 20 years for financing its proposed infrastructure project on the basis of which statement company can do so. Option A, yes, the company can issue irredeemable preference shares by passing a special resolution. Option B, yes, company can issue preference shares for period exceeding 20 years with the prior approval of central government. Option C, yes, the company can issue irredeemable preference shares for infrastructure project. Option D, yes, the company can issue preference shares for financing an infrastructure project for period exceeding to 20 years? Answer is option D. Yes, the company can issue preference shares for financing an infrastructure project for a period of exceeding to 20 years. Question 23. If company has authorized share capital of 6 lakhs, paid up share capital of 5 lakh and loan of 2 lakh obtained from the state government had directed the company to convert its loan into equity shares, then such order shall have the effect of increasing option A, the subscribed share capital of company, option B, paid up share capital of company, option D, authorized share capital of the company, option D, all of the above. Answer is option D, all of the above. Question 24. Company bought back 10% of its equity shares in August 2020. Due to certain miscalculation during the first buyback, it again bought back another 10% equity shares in September 2020 in second buyback. Valid is second buyback is valid? Option A, it can do so subject to the fulfillment of other conditions because maximum pay buyback in the financial year is up to 25%. Option B, it cannot do so because there must be time gap of 12 months between two buybacks. Option C, it can buy back shares within 1 year, but the company should pass an ordinary resolution at meeting of its boards. Option D, it can buy back shares within 1 year, but the company will have to pass a special resolution. Answer is option B, it cannot do so because there must be time gap of 12 months between two buybacks. Question 25. Swagat Hospitality Limited defaulted in the repayment of last two installment of term loans availed from the National Commercial Bank on 30th September 2019. They cleared all the dues by repaying it. When can it issue equity shares with differentiating voting right? Option A, upon expiry of 5 years from the date on which the default was made good. Option B, upon expiry of 3 years from the end of financial year in which the default was made good. Option C, upon the expiry of 5 years from the end of the financial year in which the default was made good. Option D, upon the expiry of 7 years from the end of the financial year in which the default was made good. Answer is option C, upon the expiry of 5 years from the end of the financial year in which the default was made good. Question 26. Radha, the original allotee of 2000 equity shares in Murthy Mechanical Toys Private Limited, has transferred the same to Ruchi. The instrument of transfer dated 21st August 2020, duly stamped and signed by the Radha, was handed over to Ruchi. Advise Ruchi regarding the latest date by which the instrument of transfer along with share cap certificate must be delivered to the company to register the transfer in its register of member. Option is option A, 21 August 2020, option B, 20 September 2020, option C, 20th October 2020, and option D, 19th November 2020. Answer is option C, 20th October 2020. Question 27. Shriyam Lakshmi Jewelry Store Private Limited was incorporated on 27 August 2020 with 30 person as subscriber to Memorandum of Association and with the authorized share capital of 1 crore divided into equal number of shares of 1 each. Each subscriber subscribed for 1 lakh shares. Advise the company about by with what date it needs to deliver the share certificate to the subscriber. Answer is option A, 17th September 2020, option B, 30th September 2020, option C, 20th 7th October 2020, option D, 20th 7th November 2020. Answer is option C, 27th October 2020. 28. Question 28. Kisika. Kishika, the original allotee and owner of 1000 equity share of 50 each in Modern Biscuit Private Limited, wanted to transfer these shares to her younger sister Vanshika by way of gift. She completed the transfer deed in all respect and delivered the same of the company along with the share certificate on 17th July 2020. However, the company did not register the transfer even after the expiry of more than 1 month, nor did it send any notice of refusal. The loan reminder to the company remained unanswered. An appeal is to file against the company with the National Capital Law Tribunal against his failure to register transfer of the said shares. Who has the right to file the appeal in regards? Option is A. Kanshika, who continues to remain owner and transfer of the shared equity share till they are registered in the same of the Vanshika, has the right to file an appeal with NCLT against the company. Option B. Vanshika, a transferee and potential owner of the equity share, has the right to file an appeal with the NCLT against the company. Option C. Both Kanshika and Vanshika have to file a joint appeal to NCLT against the company, for neither Kanshika nor Vanshika has authorized to file the appeal individually. Option D. As per its discretion, NCLT may allow either Kanshika or Vanshika to file an appeal against the company. Option is option answer is option B. Vanshika has, as transferee and potential owner of equity share, has the right to file an appeal with the NCLT against the company. Question 29. Vanita Watches Limited has proposed to issue sweat equity shares to 5 of its employees for the value addition made by them in term of the economic benefit which provided beneficial to the company. The period for which the employees who have been allotted the said sweat equity shares cannot transfer them in. Option A, 1 year from the date of allotment. Option B, 3 years from the date of allotment. Option D, 5 year from the date of allotment. Option D, 6 months from the date of. Option D, 6 months from the date of allotment. Answer is option B, 3 years from the date of allotment. Question 30. Prithvi Cement Limited is desirous of issuing debentures carrying voting rights. Choose the right option from the following. Option A. Prithvi Cement Limited has issued debentures carrying voting rights by passing an ordinary resolution at general meeting of the company. Option B. Prithvi Cement Limited can issue debentures carrying voting rights by passing a special resolution at general meeting of the company. Option C. Prithvi Cement Limited has issued such debentures carrying voting rights only if its mortgages, its land and building worth 2 times the amount of debentures. Option D. Prithvi Cement Limited cannot issue debentures carrying voting rights. Answer is option D. Prithvi Cement Limited cannot issue debentures carrying voting rights. Question 31. While making an application to the tribunal for seeking its confirmation in respect of execution the in respect of extinguishing the liability of rupees 3 per equity shares, Medhavi Publisher Limited has to file a certificate along with the application that the accounting treatment proposed by it for such reduction of shares capital is in conformity with the accounting standards specified in the prescribed section. Advise the company as to who can issue such certificate. Option A, any of the directors of the company as authorized by the board may issue such certificate. Option B, a practicing company secretary is authorized to issue such certificate. Option C, the auditor of the company is authorized to issue such certificate. Option D, the legal advisor of the company is authorized to issue such certificate. Answer is option C, the auditor of the company is authorized to issue such certificate. Question 32. The reserve account that shall not be used by the company for any purpose other than repayment of deposit is called. Option A, debentures redemption reserve account. Option B, deposit repayable reserve account. Option C, capital redemption reserve account. Option D, free reserve account. Answer is option B, deposit repayment reserve account. Question 33. Normally no deposit are repayable earlier than dash from the date of such deposit of renewal thereof. Option A, 3 months. Option B, 6 months. Option C, 12 months. Option D, 1 year. Answer is option B, 6 months. Question 34. Bhumi Real Estate Developers Limited has accepted Question 34. Bhumi Real Estate Developer Limited has accepted deposit from its members. There is no default in repayment of such deposit on their maturity. The statutory amount is to be deposited by the company on or before 30th April of each year in a specific account opened with its bankers till the deposit are fully repaid is. Option A, not less than 50% of the amount of its deposits maturing during the following five financial year. Option B, not less than 30% of amount of its deposit maturing during the following financial year. Option C, not less than 20% of the amount of the deposits maturing during the financial year. Option D, not less than 10% of the amount of a deposit maturing during the following financial year. Answer is option C, not less than 20% of the amount of its deposit maturing during the following financial year. Question 34. Limited company is accepting deposit of various tenures from its members from time to time. The current register of deposit maintained as at its registered office is complete. State the mandatory minimum period for which it should be preserved in good order. Option A, 4 years from the financial year in which the latest entry is made in the register. Option B, 6 years from the financial year in which the latest entry is made in the register. 8 year. Option C, 8 years from the financial year in which the latest entry is made in the register. 10 year. Option D, 10 years from the latest date of entry. Answer is option C, 8 years from the financial year in which the latest entry is made in the register. Question 36. Dream World Entertainment Limited has accepted deposit worth 50 lakhs from the public on 1 April 2019 for a period of 24 months. That is, repayment of deposit would be made on 31st March 2021. The rate of interest payable on such deposit 9% per annum. One of the depositor, Mr. Aman, requested the company on 1 June 2020 to premature repayment of his deposit of 6 lakhs along with interest. Advise the company in the said matters. Option A, the company can make premature repayment of deposit only with an intention to reduce the total amount of deposit to bring it within permissible limits. Hence, in the given case, the company cannot repay the deposit before the actual maturity. Option B, the company can prematurely repay the deposit along with interest at 9% per annum for the period of 12 months from 1st April 2019 to 31st March 2020. Option C, the company can prematurely repay the deposit along with interest at 8% per annum for the period of 12 months from 1 April 2019 to 31st March 2020. Option D, company can prematurely repay the deposit along with the interest at 8% per annum for the period of 14 months from 1 April 2019 to 31st March 2020. Answer is option D, company can prematurely repay the deposit along with interest 8% per annum for the period of 14 months from 1st April 2019 to 31st May 2020. Question 37. Suni Spice Limited decides to raise deposits of 20 lakhs from its members. However, it proposes to secure such deposit partially by offering a security worth 15 lakhs. Which of the following option best describes a deposit? Option A, fully secured deposit. Option B, unsecured deposit. Option C, partially secured deposit. Option D, these cannot be classified as deposit. Answer is option B, unsecured deposits. Question 38. What is the maximum tenure for which the company can accept or renew deposit from its member as well as public? Option A, 12 months. Option B, 24 months. Option C, 36 months. Option D, 48 months. Answer is option C, 36 months. Question 39. Ruchita wants to renew his deposits of 5 lakh with Cable Constructions Limited before the expiry of ordinary period for availing higher rate of interest. The fresh period for which Ruchita is required to renew her deposits to be eligible for the higher rate shall be option A, 1.5 times the unexpired period of ordinary deposit. Option B, double the unexpired period of ordinary deposit. Option C, 6 months for 6 months more is additional to the unexpired period of deposit. Option D, longer than unexpired period of deposit. Answer is option D, longer than the unexpired period of deposit. Question 40. Any person acquiring property on which charge is registered under section 377 shall be deemed to have notice of charge from option A the expiry of 30 days of such charge, option B the date of applicable application for registration of the charge, option C date of acquiring the property, option D date of such registration. Answer is option D date of such registration. Question 41. An interest or lien created on the property or asset of the company or any of its undertaking or both as security is known as option A debt, option B charge, option C liability, option D hypothecation. Hepto- Hypothecation. Option A debt, option B charge, option C liability, option D hypothecation. Answer is option B charge. Question 42. A charge was created by the Cygnus Softwares Limited on its office premises to secure a term loan of 1 crore availed from Next Generation Commercial Bank Limited through an instrument of charge executed by both the parties of 16 Feb 2019. Inadvertently, Inadvertently, the company could not get the charge registered with the concerned registrar of company within the first statutory period permitted by law, and the default was made known to it by the lending bankers with the stern warning to take immediate steps for rectification. The latest date within which the company must register the charge with the ROC so as to avoid paying ad valorem fee for registration of the charge is option A 27 April 2019, option B 17 April 2019, option C 2nd April 2019, option D 16 June 2019. Answer is option B 17th April 2019. Question 43. Which of the following transactions required the passing of an ordinary resolution? Option A to change the name of the company, to change the name of the company, or to option B to alter the AOA, to option C to reduce the share capital, option D to declare dividend. Answer is option D to declare dividend. Question 44. A resolution shall be special resolution when the votes cast in favor of the resolution by members are not less than dash the number of votes, if any, cast against the resolution. Option A twice, option B three times, option C three-four times, three-fourth of, option D two-third of number of votes. Answer is option B three times of number of votes. Question 45. Every listed company shall file the registrar a copy of the report on each annual general meeting within dash of the conclusion of the annual general meeting. Option A 7 days, option B 30 days, option C 60 days, option D 90 days. Answer is option B 30 days. Question 46. The AGM shall be called by giving 21 clear days notice. However, it can be called by giving shorter notice if members entitled to vote at that meeting give their consent in written or by electronic mode. In such cases, how many members have to give their consent? Option A 75% of members entitled, option B 90% of the member entitled, option C 91% of member entitled, option D 95% member entitled. Answer is option D 95% of members entitled. Question 47. Dividend once declared should be paid within dash days from the date of declaration. Option A 14 days, option B 21 days, option C 30 days, option D 45 days. Answer is option C 30 days. 48. Question 48. Which of the following amount need not to be credited to Investors Education and Protection Fund account IEPF? Option A amount in unpaid dividend account UDA of the company, option B amount of mature deposit with the company, option D profit on sale of asset, option D amount of mature debentures with the company. Answer is option D, option C 40 profit on sale of asset. Question 49. Amount to be transferred to reserves out of profit before any declaration of dividend is option A 5%, option B 7.5%, option C 10%, option D at the discretion of the company. Answer is option D at the discretion of the company. Question 50. The authorized and paid up share capital of Avantika Ayurvedic Product Limited is 50 lakhs dividend into 5 lakh equity shares of 10 each at AGM held on 24th September 2019. The company declared a dividend of 2 per share by passing an ordinary resolution mention the latest date by which the amount of dividend must be deposited in separate account maintained with the scheduled bank. On option A latest by 29 September 2019, option B latest by 4 October 2019, option C latest by 9 October 2019, option D latest by 24 October 2019. Answer is option A latest by 29 September 2019. Question 51. The directors of Silver Tongue Solution Limited proposed dividend at 80% of equity shares for the financial year 2018-19. The same was approved at an annual general body meeting held on 30th September 2019. Mr. Jagan was the holder of the 2000 equity shares of 31st March 2019, but he transferred the shares to Mr. Rajiv on 8th August 2019. Mr. Rajiv has sent the shares together with the instrument of transfer to the company for registration of the shares in his favor only on 25th September 2019. The registration of the transfer of share is pending on 30th September 2019. With respect to dividend declaration, declared the current action to be taken by the company is option A pay the dividend to Mr. Jagan, option B pay the dividend to Mr. Rajiv, option C transfer the dividend in relation to such shares to the unpaid dividend paid account, option D transfer the dividend in relation to such share to the investors education and protection fund. Answer is option C. Transfer the dividend in relation to such shares to the unpaid dividend account. Question 52. The board of directors of Zip Rice Pharmaceuticals Limited wished to declare interim dividend in the last week of July 2018. The company has incurred a loss during the current financial year up to the end of June 2018. However, it is noticed that during the previous 5 financial years, that is 2013 14, 14 15, 15 16, 16 17, and 17 18, the company has declared dividend at a rate of 8%, 9%, 12%, 11%, and 10% respectively. Advise the board as to maximum rate at which they can declare interim dividend despite incurring losses during the current financial year. Option is option A 10%, option B 11%, option C 10.5%, option D 11.5%. Answer is option B 11%. Question 53. CSR committee or board of shell consists of, and option A directors forming one third of the total of number of directors, option B at least two directors out of which one shall be independent director, option C three or more directors out of which one shall be managing director, option D three or more directors out of which at least one director shall be the independent director. Answer is option D. Three or more directors out of which at least one director shall be an independent director. Question 54. Provision of CSR are applicable to option A. Company with net worth of 250 crore or more but less than 500 crore. Option B. Companies with turnover of 1000 crore or more. Option C. Companies with net profit of 1 crore or more but less than 5 crore in any financial year. Option D. Companies have aggregate outstanding loans and deposit exceeding 50 crore or more in any financial year. And answer is option B. Companies with turnover of 1000 crore or more. Question 55. One person company shall file a company of the duly adopted financial statement to register within option A 30 days of the date of meeting at which it was adopted, option B 90 days of the date of meeting at which it was adopted, option C 90 days from the closure of the financial year, option D 180 days from the closure of the financial year. Answer is option D 180 days from the closure of financial year. Question 56. REMA formed and occupied formed and occupied the office of director in REM Stationery OPC Private Limited, which deals in manufacturing and trading of various item of statutory stationery. REMA noticed a changed provision which mandates that from the financial year 2020-21 onwards, an OPC shall file its annual return in MGT 71. REMA is also one of the director in another company which too is required to file its annual return in MGT 7A, which is that other company where Rima also occupied the office of director in addition to OPC. Option A, that other company is a small company where Rima also occupied the office of director in addition to OPC. Option B, that other company is an associate company where Rima also occupied the office of director in addition to OPC. Option C, that other company is subsidiary company where Rima also occupied the office of director in addition to OPC. Option D, that other company is dormant company where Rima also occupied the office of director in addition to OPC. Answer is option A, that other company is a small company where Rima also occupies the office of director in addition to OPC. Question 57. Ayush Power Limited has reported a net profit of 6 crore, 7.5 crore and 3 crore for financial year ending on March 2017, March 2018 and March 2019 respectively. The board's reports of the company for the year ended 20th March 2020 did not disclose the composition of the CSR committee on the grounds that the company is not required to constitute CSR meeting as net profit during the immediate preceding financial year is less than the statutory requirement laid down this section 135. You are required to examine in given scenario whether the act of non-composition and non-disclosure of composition of CSR committee in board report is valid in law. Option A, no, the act of the company is not valid in law as every company is required to constitute a CSR meeting committee and disclose the constitution of same in the board in every financial year irrespective of profit earned by the company. Option B, yes, the act of the company is valid in law as the net profit of the company is less than 5 crore in the immediate preceding financial year. Option C, no, the act of the company is not valid in law as composition and disclosure of composition of CSR committee will be required only if the profit of the company are not less than 5 crore for a consecutive preceding of 3 years. Option D, the act of the company is valid only to the extent of non-disclosure of the company of CSR committee as the net profit of the company is less than 5 crore in immediately preceding financial year. Answer is option B. Yes, the act of the company is valid in law as the net profit of the company is less than 5 crore in the immediately preceding financial year. Question 58. During the half year ending September 2019, the board directors Vidit Vidyut Manufacturing Limited has made an application to the tribunal for revision in accounts of the company for financial year ending as on March 2017. Further, during the year ending March 2020, the Board of Directors has again made an application to the Tribunal for revision in Board's report pertaining to the year ending March 2019. You are required to state the validity of the Act of the Board of Directors. Option A, the Act of the Board of Directors is valid only to the extent of application made for the revision in accounts as board reports are not eligible for revision. Option B, the Act of the Board of Directors is valid as the application made for the revision in the accounts and board reports pertain to two different financial years. Option C, the Act of BOD is invalid as the law provision provides for only one time application to be made in a financial year for revision of accounts and board reports. Option D, the Act of BOD is invalid as application made for revision in accounts pertain to a period beyond 2 years immediately preceding the year 2020. The application made for the revision in the board report is however valid in law. Answer is option B, the Act of BOD is valid as application made for revision in the account and board's report pertaining to two different financial year. Question 29. Adani Enterprises Enterprises Limited has its shares listed on a recognized stock exchange in India. During the current financial year ending on 31st March 2020, the Securities and Exchange Board of India has found some irregularities in filing made by company. Accordingly, SEBI proposed to make an application to tribunal for reopening of the books of accounts of the company. You, as an expert, are called upon by SEBI to advise with which last financial year for reopening of books of accounts an application can be made. Option A 2015-16, option B 2013-14, option C 2010-11, option D 11 and 12. Answer is option D 2011 and 2012. Question 60. Ganesh Company Limited, a public company incorporated under the Company Act 2013, has Mr. Jay Director, Mr. Sagar Independent Director, Mr. Abhishek Nominee Director, and Yes Whole-Time Director. Mr. Abhishek wants to inspect the books of accounts of Shankar Company Limited, the subsidiary of Ganesh Company Limited. You are required to state whether the Abhishek is eligible to inspect the books of accounts of Ganesh Company Limited. Yes. Option A. Yes, yes, Mr. Abhishek can inspect the books of accounts of Shankar Company Limited only on authorization of the public financial institute on whose behalf he has been so appointed, if the board of General Ganesh Company Limited appointed in the board of Ganesh Company Limited. Option B. No, Mr. Abhishek, being a nominee director, can only inspect the books of accounts of Ganesh Company Limited and not subsidiary companies. Option C. Yes, Mr. Abhishek can inspect the books of accounts of Shankar Company Limited only on authorization by way of resolution of Board of Directors. Option D. Yes, Mr. Abhishek can inspect the books of accounts of Shankar Company Limited only on authorization by way of resolution of the members holding not less than 25% of the paid up share capital of the company. Answer is option C. Answer is option C. Yes, Mr. Abhishek can inspect the books of accounts of Shankar Company Limited only on authorization by way of of resolution of the board of directors. Question 2061. For appointing an auditor other than retiring auditor, answer A. For question 61, for appointing an auditor other than retiring auditor, option A, special notice is required. Option B, ordinary notice is required. Option C, neither ordinary nor special notice is required. Option D, approval of central government is required. Answer is option A, special notice is required. Question 62. The auditor of the government company shall be appointed or reappointed by option A, the central government. Option B, controller and auditor general of India. Option C, central government on the advice of the CAG. Option D, chairman of the board of directors. Answer is option B, CAG, Controller Auditor General of India. Question 63. Which of the following is service prohibited to be rendered by the auditor of the company? Option A, design and implementation of any financial information system. Option B, making report to the member of the company on the account examined by him. Option C, compliance with the auditing standards. Option D, reporting of fraud against the company by officers or employees to the central government. Answer is option A, design and implementation of any financial information system. Question 64. The word firm for the purpose of section 139 shall include option A, an individual auditor. Option B, LLP. Option C, both an individual auditor and LLP. Option D, a company. Answer is option B, LLP. Question 65. In view of the fact that the private company enjoys a number of privilege, Orange Pharma Limited, having 20 members, in proposing to convert itself into a private company. For this purpose, the company needs to alter its article by inserting the three restrictive clauses as specified in section 2 subsection 68 and consequently change in the same of the company. Requires option A, a special resolution and prior approval of the central government. Option B, special resolution, prior approval of National Company Law Tribunal. Option C, special resolution and prior approval of Registrar of Companies. Option D, special resolution and prior approval of state government. Answer is option A, special resolution and prior approval of central government. Question 66. government. End of part 1 company law. This is end of part 1 company law. Now we'll start with part 2 others law. Question 66. A contract to save B against the consequences of any proceeding which C may take against B in respect of certain sum of 500 rupees. This is a option A contract of guarantee, option B quasi contract, option C contract of indemnity, option D void contract. Answer is option C contract of indemnity. Option 60 question 67. S and P go into shop. S says to shopkeeper C, let P have the goods and if he does not pay you I will. This is a option A contract of guarantee, option B contract of indemnity, option C wagering contract agreement, or option D quasi contract. Answer is option A contract of guarantee. Question 68. A contract by which one party promises to save the other from loss caused to him by the conduct of promisor himself or by the conduct of any other person is called A surety contract, B simple contract, option C contract of indemnity, option D contract of guarantee. Answer is option C contract of indemnity. Question 69. Any guarantee obtained by means of misrepresentation made by the creditor or which his knowledge and assent concerning a material part of the transaction is option A valid, option B invalid, option C voidable at option of the surety, option D void. Answer is option B invalid. Question 70. Mr. Sarad has recently shifted from Delhi to Noida. During the shifting, some of the furniture was damaged. Mr. Sarad gave an item to Asian Art Creators Greater Noida for repair, refabrication and painting, etc. Asian Art deals in the sale of furniture and repair thereof. It was decided that the whole work will be done on the lump sum amount of 50,000. In between this period, the workshop at Asian Art caught fire and there was no fault of the proprietor. Goods bailed by the Mr. Sharar along with another furniture destroyed in this fire incident. Mr. Sharar lost furniture due to fire at workshop of Asian Art. What is the correct statement considering there was no specific contract? Answer A. Question A. Option A. Asian Art is liable because fires took place at his place. Option B. Asian Art is liable because bailment is ongoing. Option C. Asian Art is not liable because risk of any loss during bailment is to be borne by bailer. Option D. Asian Art is not liable because fire is not due to any negligence of their part. Answer is option C. Asian Art is not liable because risk of any loss during bailment is to be borne by bailer. Question 71. Atul contracts to indemnify Neha against the consequences of any proceeding which Chirag may take against Neha in respect of sum of 15,000 advanced by Chirag to Neha. Neha, who is called upon to pay the sum of money due to Chirag, fails to do so. Advise Chirag on the course of action to be taken as per the provision of Inter-Indian Contract Act 1972. Option A. Chirag can file a suit only against Neha. Option B. Chirag can file a suit only against Atul. Option D. Chirag can file suit against both Neha and Atul. Option D. Chirag can file a suit only against Atul but not against Neha. Answer is option A. Chirag can file suit only against Neha. Question 72. The position of finder of lost good is that of a option A bailer, option B is bailee, option C surety, option D principal debtor. Answer is option B bailee. Question 73. The delivery of goods by one person to another person for some specified purpose is known as option A mortgage, option B pledge, option C bailment, option D charge. Answer is option C bailment. Question 74. With respect to contract of bailment, which of the following statement is incorrect? Option A, no consideration is necessary to create a valid contract of bailment. Option B, it involves the delivery of goods from one person to another person for specific purpose. Option D, bailment is only for immovable goods and never for movable goods. Option D, charge of possession in bailment does not lead to change in possession of bailment does not lead to change of ownership. Answer is option C, bailment is only for immovable goods and never for movable goods. Question 75. Vishal parks his car at a parking lot, locks it, and keeps the key with himself. Which of the following statement is correct in this regards? Option A, this is case of bailment. Option B, the operator of the parking lot has possession of Vishal's car. Option C, the operator of parking lot has custody of Vishal's car. Option D, this is case of mortgage. Answer is option C, the operator of the parking lot has custody of Vishal's car. Question 76. The pawnee does not have right to retain goods pledged for. Option A, performance of a promise. Option B, extraordinary expense incurred by him for preservation of goods pledged. Option D, payment of debts. Option D, necessary expenses incurred by him in respect of possession of goods pledged. Answer is option 7. Option B, extraordinary expenses incurred by him for prevention of goods pledged. Question 77. A hires a carriage from B. The carriage is unsafe, though B is not aware of it, and A is injured. Choose the incorrect answers as per the provision of Indian Contract Act 1872. Option A, B is responsible to A for injury. Option B, B is not responsible to A for the injury. Option D, neither is responsible for other. Option D, A himself responsible for his injury. Answer is option A, B is responsible to A for the injury. Question 78. Dash is one who represent to be an agent of another when in reality he has no such authority from the other agent at all. Option A, substitute agent. Option B, subordinate agent. Option C, pretendant agent. Option D, both A and B. Answer is option C, pretendant agent. Question 79. L made an offer to the managing director of the company. Managing director accepted the offer, though he had no authority to do so. Subsequently, L withdrew the offer, but company had already ratified the managing director acceptance. State which of the statement has given below is correct. Option A, L is bound by the offer due to ratification. Option B, an offer once accepted cannot be withdrawn. Option D, both option A and B is correct. Option D, L is not bound by the offer. Answer is option C, both option A and B is correct. Question 80. A is residing in Delhi and has a house in Mumbai. A appoints B by a power of authority to take care of his house. State the nature of agency created between A and B. Option A, implied agency. Option B, agency by ratification. Option C, agency by necessity. Option D, express agency. Answer is option D, express agency. 81. Question 81. Vinod, a transporter, was transporting tomatoes of Avinash from his farm to market. However, due to heavy rain, Vinod was stuck for 3 days and thus he sold the tomatoes below the market rate in the nearby market where he has stranded fearing that the tomatoes may perish. Choose the correct option in the light of the provision of the Indian Contract Act 1872. Option A, Avinash will succeed in recovering losses of tomatoes from Vinod. Option B, Avinash will not succeed in recovering losses of tomatoes from Vinod. Option C, Vinod can sell the tomatoes only at price higher than the market rate. Option D, Avinash is liable to compensate Vinod as his truck was stuck for the 3 days and hence Vinod could not complete the deliveries of other clients and thus Vinod suffered losses. Answer is option B, Avinash will not succeed in recovering losses of tomatoes from Vinod. Question 82. Jane has appointed Vinita as his agent to sell the garment manufactured by Jane. Vinita, due to her personal issue, could not work effectively. Hence, she appoints Kant to sell on her behalf. Can Jane be found by the act of Kant? Option A. No, an agent without authority cannot lawfully appoint a sub agent. Option B. Yes, Vinita is liable for the act of Kant and in turn Jane is liable for the transaction. Option C. No, Kant will be liable on his own account for any sale made. D. Option D. Yes, Kant now becomes direct agent of Jane as Kant has sold garment manufactured by Jane. Answer is option A. No, an agent without authority cannot lawfully appoint a sub agent. Question 83. Days of grace provided to instrument at majority is option A 1 day, option 2 2 days, option 3 3 days, option D 5 days. Answer is option C 3 days. Question 84. Parties to a negotiable instrument can discharge from their liability by option A cancellation, option B repayment, option C release, option D all of the above. Answer is option D all of the above. Question 85. Validity period for the presentation of check in banks. Option A 3 months, option B 6 months, option C 1 year, option D 2 years. Answer is option A 3 months. Question 86. Negotiable instrument that is payable to order can be transferred by option A simple delivery, option B endorsement and delivery, option C endorsement, option D registered post. Answer is option B endorsement and delivery. Question 87. A negotiable instrument drawn in favor of minor is option A void ab initio, option B void but enforceable, option C valid, option D quasi contract. Answer is option C valid. Question 88. As per the Negotiable Instrument Act 1881, which when the day on which a promissory note or bill of exchange is at maturity in a public holiday, the instrument shall be deemed to be due on the option A said public holiday, option B 5 days succeeding public holiday, option C next succeeding business day, option D next preceding business day. Answer is option D next preceding business day. Question 89. Which of the following is an essential characteristic of promissory note? Option A 3 must be an order to pay certain sum, option B it must be payable to bearer, option C it must be signed by payee, option D it must contain an unconditional undertaking. Answer is option A there must be an order to pay certain sum. Question 90. Mr. Ilam issue a check amounting to 25,000 dated 2nd Feb 2020 to Mr. Gandhi, which were deposited by Mr. Gandhi on 16th March 2020. In his bank account, the said check was returned unpaid on 17th March 2020 by the bank of Mr. Alam, citing insufficient funds in the account of Mr. Alam. Mr. Gandhi demanded the payment from Mr. Alam by issuing the notice of 31st March 2020, which was received by Mr. Alam on 2nd April 2020. Assuming that Mr. Alam failed to make the payment within stipulated time, what is the last date by which Mr. Gandhi should have made a complaint in court? Option A 17th May 2020, option B 2nd May 2020, option C 17th April 2020, option D 30th April 2020. Answer is option A 17th May 2020. Question 91. The preamble is most important in any legislation. It option A provides definition in the act, option B express scope, object and purpose of act, option C provides summary of the entire act, option D provides side notes often found at the side of section. Answer is option B express scope, object and purpose of the act. Question 92. As per the rules of education institution, every student may come on weekends for extra classes, but every student shall appear on the weekly test conducting institute, which means option A attending extra classes on weekends is optional but appearing in weekly test is compulsory. Option B attending weekend classes is compulsory but appearing in weekly test is optional. Option C attending weekly classes and appearing in weekly tests both are compulsory for student. Option D, attending weekend classes and appearing weekly tests both are optional for student. Answer is option A, attending extra classes on weekend is optional but appearing in weekly tests is compulsory. Question 93. Which of the following is not an immovable property? Option A, land. Option B, building. Option C, timber. Option D, machinery permanently attached to the land. Answer is option C, timber. Question 94. Where an act of parliament does not expressly specify any particular day as to the day of coming into optional into operation of such act, then it shall come into operation on the day on which option A, it received the assent of the president, option B is received the assent of the governor general, option C, it received assent of both the house of parliament, option D, it received assent of prime ministers. Answer is option A, it received the assent of the president. Question 95. As per provision of General Clause Act 1897, where an act of omission constitute an offence under two or more enactment, then the offender shall be liable to prosecute and punished under option A, under either or any of those enactment, B, twice for the same of offence, option C, either A or B as per the discretion of court, option D, under the cumulative effect of both the enactment. Answer is option A, under either or any of those enactment. Question 96. Formal legal document which creates or confirm a right or record of records a fact is option A, document, option B, a deed, option C, a statute, option D, an instrument. Answer is option B. Answer is option D, an instrument. Question 97. The rule is Haydn's case. In Haydn's case is also known as option A, purposive construction, option B, mischief rule, option D, golden rule, option D, exceptional construction. Answer is option B, mischief rule. Question 98. Pick the odd one out of the following aids to interpretation. Option A, preamble, option B, marginal notes, option C, proviso, option D, usage. Answer is option D, usage. Question 99. Which rule of construction is applicable where there is a real and not merely apparent conflict between the provision of an act and one of them has not been made subject to other? Option A, rule of beneficial construction, option B, rule of literal construction, option C, rule of harmonious construction, option D, rule of exceptional construction. Answer is option C, rule of harmonious construction. Question 100. An internal aid that may be added to include something within the section or to exclude something from it is option A, proviso, option B, explanation, option C, schedule, option D, illustration. Answer is option B, explanation. Congratulations friends, if you have watched this video till end. I'm going to make lots of videos on MCQs, more videos. I'm not next video will be on case based MCQs, and after that I will be covering all the mock tests, revision test papers, suggested answers, and other notes MCQs to fully cover the company accounts and other laws MCQs. So all the best for your exams, and do revise and do practice and just listen these MCQs. It will help you a lot in recalling your notes and for your divisions. Thank you so much.